There are, of course, numerous other issues in California that would cause a person to be prohibited. One of the ones that I get asked about more often than any other, besides criminal convictions, are what are called 5150s, 5250s. Basically, these are temporary psychiatric holds initiated usually by law enforcement that they believe, for whatever reason, that you are a danger to yourself or others. And for that reason, they're going to take you to a medical facility for evaluation. And they have 72 hours from the point at which that is initiated for a medical professional, i.e. a doctor or a judge, to determine whether in fact you are a danger to yourself or others. But just because you were taken in by law enforcement on a 5150, California automatically imposes a 5-year restriction on owning or possessing firearms. And of course, recent changes to that law also dictate that if you have multiple 5150s, that could cause a further restriction time-wise. Now, what you need to understand is that a 5150 can be dealt with in what's called an 8103 hearing. And what that means is that an individual can petition a court to have that 5-year restriction lifted early. And in lifting that restriction early, you would therefore get your rights to own or possess firearms back. It is a one-time petition process, meaning that if the court denies it for whatever reason, you're sort of SOL for the rest of the 5-year period. Generally speaking, what I recommend individuals do that are subject to a 51 prohibition, that are wanting 5150 prohibition, that are wanting to get their restriction lifted early, is to, before reaching out to an attorney to help with the petition process, reach out to a psychologist or psychiatrist and ask them to make an evaluation, a written evaluation, that definitively states one way or another that you are or are not a danger to yourself or others. And that is something that can then be attached to the petition and filed with the petition and given to the judge. And generally speaking, a judge, being a lawyer, unlikely being a medical professional, isn't going to second guess a medical professional's opinion. Same being true of the district attorney's office, who would be the opposing party in such a motion. And so if you were able to get a medical professional opinion that says you should have your rights restored, that you're not a danger to yourself or others, generally speaking, that should be sufficient for purposes of getting an 8103 hearing ruled on in your favor. I can tell you from personal experience, we have had individuals reach out to our office, retain us to file the petition, but afterwards then sought the assistance of a medical professional to make such a report. And we've gotten that report back, and the report said there's no way in hell this person should own or possess firearms. This guy's a danger. So we're sort of stuck at that point. You know, the guy's already paid us to file the motion, had to go forward with it anyway without the medical professional opinion. So before you even reach out to a lawyer to help you with that, I suggest that you reach out to the psychologist, psychiatrist first as the first step. You also typically want to wait a couple months, usually around 6 months or so from the date the 5150 was initiated. Because if a judge sees you trying to apply for it, you know, right off the bat, right out of the gate, right after you were determined by law enforcement to be taken in for a 5150 hold, they might deny it as well. So, don't even file the petition until you have all your ducks in a row, basically. Otherwise, it's going to be a waste of time, and you might not get your restriction lifted, and then so you're sort of stuck for the rest of the 5 years. The other thing a 5150 can potentially do, and this is the bigger issue, is that it could be turned into what's called a 5250, where after you are taken in by law enforcement, a judge or a medical professional does deem you to be a danger to yourself or others, and holds you beyond 72 hours. It could be as little as a day, a couple hours even, but by the simple fact that you are being held beyond 72 hours, triggers the 5250 restriction in California, which again is a 5-year restriction and does, under California law, have a petition process to get the restriction lifted early. However, because it is now a doctor that is determining you to be a danger to yourself or others, or even potentially a judge, that also triggers a federal restriction under the Lautenberg Amendment. Under 18 U.S.C. 922G, you are now prohibited for life from owning or possessing firearms as a result of being held on a 5250. And so while plenty of individuals have gone through the process of getting the 5250 restriction lifted in California, that of course has no effect on the federal restriction. And as I talked about earlier, if you are subject to a federal restriction, there's generally no means by which you can petition the federal government to have that restriction lifted early. It is also not a criminal offense, meaning it is not something that the governor of California nor the president of the United States can issue a pardon for. And so this is something that really the only possible way an individual could petition to have or get their firearm rights back after being subject to a 5250 is to challenge the constitutionality of the 922G prohibition as applied in their circumstances. And that is a very, very, very tall order, at least under current law. It is something that, for the most part, there are almost going to be a 100% failure rate for those types of cases, because the 922 prohibition that we're addressing here as a result of the 5250 has been upheld as constitutional, generally speaking. So it is kind of a problem for a lot of people. So you can see lots of bikers out today. Good.